Good evening, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to come back on today and talk to everybody about arbitration. And if you see the text in the post, it tells you what arbitration is, how it works. It's a private process, third party. You're going to hire a third party, like it says, private third party. So if you want them involved, you have to contract with them. So make sure you include an arbitration clause with that contract too. But the basics of arbitration, again, if you read the text, it's a common law right. It's a right to be able to go to your brother and make amends. And we'll get back to that word amends here real quickly, but pay attention to it. It's a right common amongst all men to be able to go to your brother and make amends. And this we see in Matthew 18, verse 16, where it says, "But if he will not hear thee, then take with thee one or two more, that in the mouth of 2 or 3 witnesses every word may be established." So if you go to your brother and he doesn't listen to you, you have an inherent right to a third-party witness to validate what's happening. You know, he put forth a accusation, a complaint, a contract. He engaged in commerce, tried to enforce me to engage in commerce with him, whatever it may be. You go to your brother and he doesn't want to accept that, okay? Then you go to an arbitrator. You get that other witness. And you have him sign on. Okay. Now I'm going to step up to Title 27, Code of Federal Regulations 72.11, wherein we're going to show that everything's commercial, everything's a contractual thing. It's all commerce. And when we talk about 27 Code of Federal Regulations, it says commercial crimes. Any of the following types of crimes, federal or state, offenses against the revenue laws. Offenses against the revenue laws. Burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses. Extortion, swindling, confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crimes. So everything's being treated as a commercial activity, thereby being a taxable event, and thereby that's what they're doing with the bonds and everything. They're performing commerce with the bonds, and those bonds are in direct relation to the contract that they're trying to construct. Comprehend this, people, that they're trying to construct. It is not set in stone yet. It is already in an arbitration. That's what coming to terms and agreements of a contract is arbitration. Okay? So that's the very first element of due process, is the arbitration process. Now, if an officer pulls over alongside the road and pulls you over alongside the road and issues you a citation, that's the beginning of an arbitration process, but there's no arbitration clause in there. So you conditionally accept. This is what I'll do if I get a ticket again. I'm going to line through that promise to appear. I'm going to line through appear. I'm going to put arbitrate. I promise to arbitrate. I've just now accepted and conditionally amended the contract, not to appear, but to arbitrate. And that's as little as it takes if you really think about what you're doing. Now, you have to have a little more knowledge to back that up, because they're still going to try to push it on you. They're still going to try to profess some kind of warrant or something for failure to appear. That's when you try to, when you go ahead, if you're confident enough, to walk into that court and hand them that document. Hand them that conditional acceptance. Have a witness with you that'll sit there and say, yeah, he accepted it, or no, he refused it. It gives you a right to arbitration. You have it in the instrument, hand it to him. He's just accepted arbitration. If not, acquiescence to the new contract that you've amended, and he is now dishonoring his initial offer of the contract. See, the issue isn't with the judge, it's with the officer. The officer is the other signature on that contract. So if I line item through that appearance, the word appearance or term appearance, and put arbitration in there, now I've inserted a contract, arbitration clause in that contract, and now it's time for him to meet me in court and let's arbitrate that. That judge is now arbitrator, isn't he? Let's get that officer up there and let's talk about this. Let's get this settled right away, expediently, so the court has less expense in it. Learn the terms and conditions of contract, and you can have that officer crying. It's how important this arbitration stuff is, but you've got to learn it. So I put a lot of information out here in the last couple days on it. I'm going to go through some more here. But everything is considered commercial. So every time you even get pulled over before you're signing, it's considered commercial. Once you sign, it's considered commercial. When you go to the hospital and you sign emergency papers, it's considered commercial. It's a contract. So we have to think about this and everything. We better make sure that we're finding out whether there's a arbitration clause in there. If not, we need to insert it. Conditionally accept with insertion of arbitration clause, not limited to the arbitration clause, but may possibly include such things as bond issues and such. You know, you might want to step up to the plate and accept that entitlement of enforcement of right to be the principal investor on these bonds. That's your subrogation. It's all part of arbitration. It all extends from the common law right of arbitration. Like I said, go to your brother. It's in the Bible. Matthew chapter 18, verse 15 through 20. Tells you about how to go to your brother. If he doesn't listen, you get an arbitrator. You give him a witness, have him witness your statements, go to a third witness, present your judgment. They give you a writ of execution. It's actually pretty simple. But when you start including all the other stuff about jurisdiction and bonds and everything, you got to know what you're talking about. If you don't know anything about the bonds, then I wouldn't suggest you do anything in there about the bonds until you learn about them. Or maybe get a assistance of counsel of somebody that does know about the bonds. You know, talk to one of these guys like Derek Gonzalez, Timothy Emmett Damron, Iran Lopez. They seem to know quite a bit about the bonds and how they work in the court. Ask them for some help. If you've got a binding contract and an execution of a judgment, and you've got information in there on how to collect the bonds, you should be able to assign payment to them out of the bonds. If they know what they're doing, have them help you get the bonds. They get paid by helping you get the bonds. Once the bonds are retrieved, that's how you get paid. You step up and take responsibility to pay for the taxes through the 1099 OID process. But again, like I said, don't get stepping in unless you know what you're doing, because it could be a big pile of shit. So anyway, let's get on to the next thing. The next thing I want to talk to you about is, of course, we're talking everything that's contractual or commercial. It's all commercial. So we're going to go to the Uniform Commercial Code. Okay, Uniform Commercial Code, under 1-103, we're talking about the construction of the Uniform Commercial Code. In other words, its basic intent. It says code to promote its purposes and policies. Applicability to supplemental principles of law. Arbitration is a common law right and it is an extended principle uniform throughout all jurisdictions. Listen here, people. The Uniform Commercial Code must be liberally construed and applied to promote its underlying purposes and policies which are to simplify, clarify, and modernize the law governing commercial transactions, to permit the continued expansion of commercial practices through custom, usage, and agreement of the parties. And 3, to make uniform the law among the various jurisdictions. So when we're talking about the common law right of arbitration, we're talking about this uniform commercial code right here says that their purpose under the principles, supplemental principles of law, which includes arbitration. Therefore, its purpose is to include arbitration uniformly, even in the commercial code. And that's why contracts are presumed to automatically have an arbitration clause. Why? Even the construction of the Constitution of the United States has an arbitration clause in there. It's called a Commerce Clause. Look it up. Look up the definition of a Commerce Clause. Look up Supreme Court cases on commerce cases. And then look up Supreme Court cases on contract cases. See if they aren't quite similar in cases, but yet the cases are all different. What's the difference? They're all contract, they're all commercial. The difference is the stage. Right now, we're still in arbitration. When we get a writ of execution, that's the final judgment. See, these guys sitting in jail, they're still sitting in jail and in prison because the contract hasn't been finalized. Bonds haven't been secured. All these bonds floating out there, they can't possibly be secured unless somebody is putting up a substance. As far as I know, all those bonds are purchased and traded with Federal Reserve notes or an exchange of like kind, you know. So think about this stuff, people. Uniform throughout the to make uniform the law among the various jurisdictions. And the very basic principle of supplemental law is things that are either attached to it or part of it. And so part of the commercial law is your right of arbitration, period. That's your unlimited powers of contract. Simple. So now we're going to talk about, first I'm going to have you look up, in regards to arbitration, Federal Mediation and Conciliation Service. And this is where it's going to talk about Title 29 of the Code of Federal Regulations, Part 1404, Arbitration Services. Now, if you look again at the text in the post, it tells you arbitration is a private procedure. It's a private process. Now, we can go through the federal regulations, Code of Federal Regulations as arbitration services, and still maintain a private party. These guys are acting in their personal capacity. If you're going after these other people in their individual capacity because they've committed a trespass, some kind of tort, they've dishonored their offered contract, these guys would still be considered a private party. And comprehend, these guys follow the UNCITRAL, UNCITRAL. I can't remember exactly what it is, but it's the one through The Hague on arbitration. It's the international arbitration laws there. This here we're talking about federal. But you can still look up private arbitration and mediation services in your area and still agree to hire an outside private arbitrator aside from a government body. You don't have to hire these guys. It just has to be one of competence, one that knows the process and is willing to support the validity of your contract once he's made that decision, or stand behind his decision if he says it's not valid. And if he says it's not valid, you have to comprehend why he's saying it's not valid so you can go back and fix it. Like I said, these guys sitting in prison and stuff, that's because the contract hasn't been finalized. Once the contract is finalized, nobody else can further it any further, whether it be by performance, detriment, benefit, putting in further consideration. Once a contract is finalized, it's finalized. Once a contract is canceled, it's canceled. Once it's terminated, it's terminated. But unless one of those things is happening, it's still a valid contract in the eyes of the law. So until somebody steps up and fixes the bond issue on those cases, you're past arbitration. You can go for renegotiation and arbitrate the bonds. You've already succeeded in spending all that time, which you really, unless you can actually prove fraud, going to be kind of hard in some situations. But you're going to have to learn how to step up and renegotiate. You're going to have to learn how to do the contracts. That's what arbitration's all about, contracting. If you don't comprehend contract law, then you're never going to comprehend arbitration, mediation, reconciliation, all of that. They're synonymous. It's called communication. It's called language. It's what I keep trying to explain to everybody. It's the basic problem is the communication. It's the language. It's how we talk to each other. It's not the people that do these things that I don't like. It's the things that they do that I don't like. And so I need to go to them and say, hey, listen, I don't like what you just did. I don't have to get all mad. I have to act in the appropriate capacity and love my brother love my neighbor as myself. And so if I want somebody to come to me appropriately, I got to go to them appropriately. So I need to go to them as Matthew 18, verse 15 through 20 explains, and try to make amends. If he's not willing to make amends, then I have to make amendments to the contract, conditionally accepting it, and go from there. And it just depends on the situation you're in, on what those conditional acceptances are. But I will always urge from here on out to include an arbitration clause, which is something that most of them do not do. This is I did some research on what's called a clawback clause. In regards to you guys that have people in prison still on these bonds and stuff, a clawback clause is in regards to a contract where if something is found to be wrong, erroneous, you can go back in a point in time and fix it. Okay? And so what you do is you go before the court, forgive me my errors as I forgive those who have erred against me. From this point on, we establish a renegotiation of the contract. I need to arbitrate. I need an arbitration service in order to finalize the contract so it's no longer detrimental. I've come to find out that spending all this time in prison is detrimental to myself, my family, my wife, my kids. And I no longer wish it to be a detriment. I'd like to remedy the situation. And we have a right to do that. We have a right to go before our brother at any time. And so I urge you to look up this arbitration stuff and learn it. So now we're going to go, but anyway, Federal Mediation and Conciliation Service. This is going to give you the arbitration services. It says Subpart A, Arbitration Policy Administration of Roster. So when you use them for arbitration service, they make up a roster. So you can go on here and find the roster. Then it's going to, section 1402, it says scope and authority. It'll explain the authority. Policy, administrative responsibilities. It'll give you the roster. It says here, Subpart B, roster of administrators, admission and retention. Roster and status of members. So we already know it's a member association. Is it a private member association? I'm betting it probably is. But it's under contract for the federal government. Well, in regards to the federal government has a national policy under UNCITRAL to abide by arbitration policy. So if you come in as a foreign state, even to the United States, and these foreign mediation and conciliation services, you prove that you are definitely 1, 2, 3 parties. So think about this stuff and realize you don't have to let this stuff instill fear in you. You can still use them. You just have to know their placement. Don't let them disposition you. You have to know how they are positioned in it. And again, like I said, you can still hire an outside arbitrator. You can make the arbitration clause primarily your arbitration clause where they don't get to agree to it. That's done through acquiescence. If you present it in the right way and they acquiesce to the entire thing and just totally ignore you, boom, you've already stood up and went to your brother. And as the instructions in the Bible say, next you go get your second witness. Your second witness is you present it to an arbitrator. You go get an arbitrator and you say, okay, now this is what he offered. This is how I conditionally accepted it. This is the amendments that show those conditions. And this is how he responded or he hasn't responded. And then the arbitrator makes his decision upon contract law as to whether you now have a valid contract. They made an offer. You accepted the offer, and now they're standing down in dishonor by not answering you. You have a valid contract on your side. If you fight it in the wrong way, the arbitrator sees that they have the valid contract. It's a valid contract either way. It's a matter of determining who's got the validity in it. So when you get this stuff, like I said, it's a matter of continuity and closure. Look up the law of continuity and the law of closure. And you'll see that you can't have a full circle if you draw a bunch of dots. That's not a circle. That's symbolic. It is not continuous. That is not continuity throughout. So when we get these facts presented that are that don't have full continuity throughout, explaining that though he was accused of being of driving, he was not actually driving. So we fill in these amendments that stick them in a corner. Admissions. I conditionally accept that I was driving upon the... I accept the fact that Keith Orland Little was driving on the condition that the officer can prove that there were commercial activities transpiring at the time he pulled me over. At the time he pulled myself over. As authorized representative of Keith Orland Little. You know? And it's just a matter, again, language is key. Learning how to speak to these people. Making these amendments. And so when we think about arbitration, the first thing we look at in regards to the federal code, Title 9 of the United States Code is your arbitration code. And like I said, it's a common law right. And in the Title 9 of the U.S. Code, arbitration, it tells you it's the access to common law court of record. Says it right in it. Read this section and you will see this is your access to common law court of record. Now, if you behave appropriately in the common law by abiding by Matthew 18 verses 15 through 20, and you go to your brother, and he doesn't listen, you get a second witness, and then you go before a third witness. You get the arbitrator to agree that you have a valid contract. That's your judgment. Now you go before a third witness, which is the federal courts, 9 U.S.C. arbitration. Okay, you can present your judgment to them and say, hey, this is my judgment already I got from a third-party private arbitrator. And they're going to be able to walk you right through right there for a writ of execution. Or you can go through your a private arbitrator and try to go through small claims court if that's all you've got coming as an award. But I suggest using the 9 U.S.C. It tells you it's the instructions for the arbitration procedures, and as well as that federal mediation and conciliation services. It's going to tell you all about it. And anyway, under 9 U.S. Code Section 1, it says maritime transactions and commerce defined, exceptions to operation of title. And what I want people to comprehend here is the way they've worded this or termed this if you look at it, it says maritime transactions, and that's in quotes. And then it says and then it says commerce, in quotes, defined. And when we look down here, it says, and it's a short section, short section, it says maritime transactions, as herein defined, means charter parties, bill of lading of water carriers, agreements relating to wharfage, supplies furnished vessels or repairs to vessels, collisions, or any other matters in foreign commerce, which, if the subject of controversy, would be embraced within admiralty jurisdiction. Commerce, as herein defined, means commerce among the several states or with foreign nations. Well, commerce here is blue line highlighted. So when we click on that, guess what? It brings us exactly to 9 U.S.C. 1, the very definition we're reading. And what that tells us is that commerce is synonymous with maritime transactions. So every time you perform any kind of commercial transaction, you're acting in maritime, which is part of admiralty jurisdiction. Okay? Admiralty jurisdiction is the one that stands up for the one that has right of entitlement of enforcement. Now, the only one that has entitlement of enforcement is the one that can show it on the record. So when they present their offer, and you just flat out reject it, without putting it on the record that you have a new contract that is validated, it doesn't matter what you do. Their contract is still considered valid. They are still considered the one with entitlement of enforcement. And this is the presumption that we have to beat in law. The only way you can do that is not by hiring a lawyer. If you hire a lawyer, you're saying that you're willing to go forth with the contract terms and conditions as they are, without inserting an arbitration clause, which is your common law right, to say, whoa, wait a minute, something's wrong, I'm suffering detriment, let's talk about this. And that's all it is. Nothing more, nothing less, and that cannot be commercialized. Just like your right to travel, it cannot be commercialized. Just like your right to freedom of expression, it cannot be commercialized, whether you want to speak or whether you want to write it down in scriptural language, or if you want to draw a pretty picture and let it be taken as 1,000 words. Doesn't matter how artfully you wish to express yourself in any form. You have that right at all times, for any reason whatsoever. You have it to express joy if the contract goes good and you benefited for more than what you expected. If you go out to the casino and you drop a coin in that machine, that's a commercial transaction. You just performed a contract in essence with the casino. And it is dependent. It has not been finalized yet until you pull that lever and that wheel stops and the determination has been made that a benefit is coming, that the ledger is balanced. You need to renew the contract. When you guys get out of jail, I suggest you quit signing these release papers. They're releasing you, all right? You're signing another contract. If you really don't want to do that, learn how to do this stuff appropriately. Well, let's talk about this. So anyway, we're going to go to section 9 U.S.C. number 2. Again, I suggest you guys read this. You'll see the whole part. Section 2, again, is very short. 9 U.S. Code 2, validity, irrevocability, and enforcement of agreements to arbitrate. Enforcement of agreements to arbitrate. A written provision in any maritime transaction or a contract evidencing a transaction involving commerce. Well, if it's any maritime transaction, it is commerce, so it's already evidence commerce. If it's a contract involving an economic substance, then it's already evidencing commerce. If it's asking fines, fees, penalties, taxation, registration, compensation, anything regarding a debt instrument, not substantial exchange of goods or services, then it's requiring a maritime contract. It's a commercial event, a taxing event. It's going to cost you. A written provision in any maritime transaction or a contract evidencing a transaction involving commerce to settle by arbitration. A controversy thereafter arising out of such contract or transaction. What I want to point out to you here, we hear these people telling you can't bring controversy into court. You don't want to bring the controversy into court. You want to put the controversy on the paper. You want to explain by conditional acceptance that there's a controversy here, that thereafter you're now including an arbitration clause because of that controversy, because that any further actions would be detrimental. You have a right to not take on detriment. That is not the purpose of a contract. Taking upon a detriment can end a contract and is termination or cancellation of a contract by operation of law. All you have to do is point out that it is detrimental. Again, you people with guys sitting in jail, if you can comprehend this, they can literally, if they know how to enforce this, say, I apologize, please forgive me as I forgive the court. I have made an error. I wish to come forth now and renegotiate the contract under arbitration or arbitration agreements, that I suffer no more detriment, as it is detrimental that my family be without me and I be without my family. That is where I belong. I have a right to be availed. So anyway, to settle arbitration by a controversy thereafter arising out of such contract or transaction, or the refusal to perform the whole or any part thereof, or an agreement in writing to submit to arbitration an existing controversy arising out of such a contract. Again, so we see the same thing, arising out of such a contract, an existing controversy. We now recognize it. My apologies, please forgive me. I now recognize it. It was existing back then. I now recognize it. I place it on the record. Please forgive my error. Transaction or refusal shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. In other words, if, for instance, you contracted with a minor, they might take the extent that you couldn't contract with a minor, therefore the contract wasn't valid to begin with, therefore it isn't under arbitration. See what I'm saying? You can't move forward in an arbitration of contract if there is no valid contract to begin with. Here, we're accepting on and for the record that there's a valid contract. The officer signed the ticket and then you signed it. That's a valid contract. Okay, now that there's a valid contract, what are we going to do? Well, the thing is to know what we do before we sign it. Line item through up here and put arbitration. UCC 1-308 and your old John Hancock. There you go, buddy. I got my copy. You got yours? Okay, I'll send you a notice here within 3 days on my selection of arbitrator. Let's talk about this. What's he going to do? Is he going to hand it over to the prosecutor? If he hands it over to the prosecutor, has he just made the prosecutor arbitrator? Sure, if you want to. Go talk to the arbitrator and say, hey, I'm cognizant that Officer so-and-so here, whom I've contracted with, has entered you into this contract as a quasi-third party. Now, I can only assume that he did that as an arbitrator. Is that the position you propose you're playing here? Are you representing him, or are you sitting as an arbitrator? I'd like to make you aware that I entered an arbitration clause here. If you're party to that arbitration, I'd appreciate the contact information. If you're not, do I need to include yourself in this contract? Bind that guy. Bind that guy. I almost lost it. I almost called him a name. So I do work on it, people. I do work on it. A man's intellect is limited and biased by his vocabulary. So think about this stuff, people, and realize you have an unlimited power of contract, but the only way you can enforce that is by learning it. And I highly suggest that you get on here and learn this stuff as quick as possible. I've been putting out as much information as I can in regards to the PMA and how to present yourself as a foreign entity. And now we need to progress along the well, and actually it's actually I need people to comprehend this is actually the starting point. If you're going to do any kind of contracting, if you're going to perform any kind of commerce, you got to be ready to arbitrate. When you go to a garage sale and you want to talk that guy down on that tread walker from $25 to $15, you're in arbitration, right? You're in arbitration. That's what you're doing. You're talking to him. That's all it is. So when it talks about going to your brother and make amends, it doesn't mean that necessarily that your brother accused you of something wrong. It means that your brother's wanting to contract with you. He's wanting to come to agreements too. Love thy neighbor as thyself. If he lives by the same measure, then he isn't wanting to start a controversy. He wants to come to an agreement with me. Well, let's go talk to him again and find out what kind of agreement we're talking about. Let's enter into an arbitration, because I don't know, the way this looks to me, it looks like you're making an accusation, and so let's clear this up. You know, I admit that, you know, it might look like I was driving, but can you concede that I was performing commerce at all? I mean, really, come on, brother. Let's get real about this before you go running your mouth out to the public and tell them I was driving while I was drinking. Yeah, let's be real. I wasn't driving, and yeah, I was drinking a pop. So you just gotta think about it without emotions, I guess. This is one of the things that I'm learning about the most here lately. If you saw my previous video about being a belligerent, my apology. That's why I'm going to work on correcting my own language. But at the same time, I need other brothers and sisters to step up and start learning this stuff diligently. Because like I said, the first step in due process of any law, no matter what procedure you're following, what administrative procedure you're following, the first point in due process is to go to your brother and talk to him. You don't go to him bearing arms. You don't go to him as a belligerent. You don't go to him kicking and screaming. You tell that officer, okay, here, I'll give you my driver's license as a form of knowing who I am as a man, but comprehend this is just in the capacity of commerce. I'm not acting commercially, so I will see you in court. Go ahead and feel free to issue a ticket or citation or whatever if you wish. I'll be glad to sign that contract with you, and I'll be glad to see you in court for arbitrating. Don't argue with him alongside the road. You have a right to within 72 hours. Go ahead and he's already given it to the prosecuting attorney. That's presumptuous. Go to the prosecuting attorney and tell him you assume you've been notified, as it's part of the process. You're just here to clarify whether they're part of the arbitration process, or if they really want to try to prosecute, if they really want to try to move forward this contract, this trust in construction, this constructive trust of a contractual nature based on an economic substance, seeking fines, fees, and penalties, which is a commercial transaction, thereby a taxing event. I mean, God, there's a lot of bonds and stuff I'm going to be pulling out of this little measly $150 traffic ticket. You really want to go through with this, or should we sit down and arbitrate? You know, when you're able to start pouring this information on them and letting them know you're willing to enter an agreement under your PMA and make it a binding contract, and let's do this in individual capacities. I guarantee you, if you know what you're doing, they're going to run. Because all they're doing, most of them, they're just doing what they're told. They still don't know what they're doing. They're just doing what they're told. A lot of them don't know about the 1099 process. A lot of them don't comprehend anything about it. They haven't been able to put it together because they spent all their life doing what they're told instead of doing some research. And even then, they're researching what they're told to research. Look up sovereign citizen, and you'll find all kinds of research on sovereign citizen. Look all you want. It's a matter of how you discern it for yourself. And that's dependent upon what else you research. So when you open your mind and you start researching all this stuff and you realize the scope of it and how much control you really have by just saying, nah, I don't think so. Here, let's go to the third party and talk about this. I don't agree with that. Let's go to the third party and talk about this. Because then you get to leave out the emotions and shit and stuff like that out. I almost cussed. It's a lot funner game that way. Get to look at it. Well, what do you mean 1099 has relevance? Objection, relevance. Really? How would you like to talk to Sam's about that? Systems acquisition management. Well, what's a system? Well, we're talking about the financial system here, and it's dependent upon the Social Security account, which is the person named in the instrument here before this court. Those are the funds you're trying to transmit. Those are the ones that have credits upon one side of the ledger that we're supposed to offset. They go, huh? So think about this stuff, people, and realize you have a private right of arbitration that extends into the public law, uniform throughout among the various jurisdictions. It's a private right that is uniform throughout the jurisdictions, just like travel right, just like your freedom of speech. And one thing real quick I want people to comprehend, the preamble to the Constitution in and of itself is a contract. It's an implied contract by the words used. Let me point something out to you. It starts out, "We the people of the United States," and ends with, "do ordain and establish this Constitution for the United States of America." We the people of the United States, in order to form a more perfect union. Union. Can you say bond? Can you say contract? Can you say binding? The Constitution itself, by the verbiage, tells us it is a contract. It is written in the nature of a contract. We, the people of the United States, in order to form a more perfect union, establish justice, meaning that it hasn't been established yet. When are we going to fix that part? Well, there will never be justice. Why? Because there will always be some kind of injustice, and that isn't pure justice. It's like It's like a holy fruit of a tree. If the fruit is holy, then the tree is holy. If the root is holy, then the tree is holy. If the fruit is rotten, is the tree rotten? Different concept. We got to think about this stuff. And that's why we have to realize there's a dependence on government. And if we depend on that government, are we acting like that government? Or are we using something else to be able to enhance that government and bring it out of the corruption? Establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare. Promote the general welfare. The general welfare. What's welfare? Welfare is the health and well-being of each and every person, each and every individual. That's the welfare. And they're wanting to promote the general welfare and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. That tells us that there's a binding, arbitrary agreement. Look that one up. Binding arbitrary agreement. And therefore it's a contract with arbitration. The government is bound. And we see that in the 9th, 10th, and 11th Amendments. It's also bound in the First Amendment. Congress shall make no law establishing respecting the establishment of a religion. Why? Because they're here to establish justice. Think about this stuff, people. I want you to really think about this stuff. Matthew 18, verses 15 through 20. If thy brother shall trespass against thee, go and tell him his fault between thee and him alone, privately. If he shall not hear thee, if he shall hear thee, thou hast gained thy brother. But if he will not hear thee, then take with thee one or two more, that in the mouth of 2 or 3 witnesses every word may be established. So now you do a service of process. You have somebody else serve them as a witness. Now you've got a service of process. And if he shall neglect to hear them, tell it unto the church. Now you're going to express it to an arbitrator. But if he neglect to hear the arbitrator, let him be unto thee as an heathen man of the publican. Verily I say unto you, whosoever ye shall bind on earth shall be bound in heaven, and whosoever ye shall loose on earth shall be loosed in heaven. Again I say unto you, that if 2 of ye shall agree on earth as touching and anything that they shall ask, it shall be done for them of my Father which is in heaven. You go forth to the tribunal with your arbitrary agreement already judged with a writ of execution. Boom. You're in his presence. You've got 2 witnesses saying, yeah, it's valid. You've got yourself validating it, and that's your word. You've got an arbitrator saying, yes, he put it forth. I witnessed it. I concede that it is a valid contract. For where 2 or 3 are gathered together in my name, there am I in the midst. Genesis 17, verse 1, I am Almighty God. As long as ye follow my way, thou shalt be blameless. Therefore, I've just proved myself blameless. Writ of execution, please. It's pretty much that simple. But you got to gain a lot of knowledge to get to that point, to realizing how simple it is. And Title IX of the United States Code really isn't all that long, people. It really isn't all that long. We've got 3 chapters. Chapter 1 is general, and that goes 1 through 16. Second chapter is Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Foreign arbitral awards. I think this is where they're going to talk about UNCITRAL or something probably. But UNCITRAL is the arbitration, the International Arbitration Agreement through the Hague. And it says the Convention on the Recognition and Enforcement of Foreign Arbitral Awards of June 10th, 1958 shall be enforced in United States courts in accordance with this chapter. And this is all stuff everybody needs to start looking up. Because, again, like I said, it's not a long title. Agreement or award falling under the convention, jurisdiction, amount, and controversy. Venue. Let's look at venue. An action or a proceeding over which the district courts have jurisdiction pursuant to Section 203 of this title may be brought in any such court in which, save for the arbitration agreement, an action or proceeding with respect to the controversy between the parties could be brought, or in such court for the district and division which embraces the place designated in the agreement as the place of arbitration, if such place is within the United States. So basically, if you're having a problem with the state courts, it's telling you can take it to federal court. And if you're having a problem with federal court, you can remove to state courts. And here it says, in the next one, it says, Section 205, it says removal of cases from state courts. Removal of cases from state courts where the subject matter of an action or proceeding pending in a state court relates to an arbitration agreement or award falling under the convention. In other words, that's why you don't want to use the state laws in regards to arbitration. You want to access your federal courts arbitration because it's subject to the UNCITRAL, your international arbitration. The defendant or defendants may, at any time before the trial thereof, remove such action or proceeding to the district court of the United States for the district and division embracing the place where the action or proceeding is pending. And this is what I want you to comprehend, people. These district courts in the states that are acting as state courts are still district courts of the United States. It's still a United States district court. It's just in the state of Iowa. That's all it is. A district court is a district court of the United States. It's a court of limited jurisdiction. It's a court of commerce. That's why it's limited. It's limited to commercial actions, period. 11th Amendment, the Commerce Clause. The procedure for removal of causes otherwise provided by law shall apply. The procedure for removal of causes otherwise provided by law. That's your supplemental principles of law. The procedure for removal of causes otherwise is provided by common law right of arbitration. Period. Uniform throughout uniform among all jurisdictions. Except that the ground for removal provided in this section need not appear on the face of the complaint, but may be shown in the petition for removal. So all you got to do is submit a petition for removal to federal courts based on common law right of arbitration. You have a right to mediate through federal mediation and conciliation services for your United States citizen. You have a right to access the benefit, the services of a United States citizen. Think about this stuff, people. For the purposes of Chapter 1 of this title, any action or proceeding removed under this section shall be deemed to have been brought in the district court to which it is removed. For the purposes of Chapter 1 of this title, any action or proceeding removed under this section shall be deemed to have been brought in the district court to which it is removed. And my interpretation here, people, in regards to if we're going to really chase after the bonds and stuff, what this is telling me right here, and I don't want anybody else to misconstrue it, because this is only my how I discern it, that I would want to go to court of original jurisdiction. And when I speak of court of original jurisdiction, that would be my court, and that would be the court wherein my records are registered. The county registrar at the birth county. So I would want to remove, say if I'm in Missouri here and I've got a case that they have pending against me and I want to remove it for arbitration, I would do so through the District Court of Johnson County of Dubuque, Iowa. Relating that it's its original jurisdiction, because that's where the original records generated from upon my being born live. That's where the original born live statement exists in regards to all commercial transactions that extend from that personage, that conferring of nationality. And I believe that's what this is talking about here. It shows your true inherent nationality by your born live statement. You're born naturally, not as some kind of confined native or national or any kind of fictional construct of a noun or anything like that. You're born live as a natural being, succinctly put, without any of their legalese. And I think that's what this is telling us here. So anyway, I want people to think about this. I posted several videos here lately in regards to arbitration. I posted the definition of arbitration according to Black's Law. When I get done here, I'll include a link to the Federal Mediation and Conciliation Services. You can just look it up, fmcs.gov. Federal Mediation and Conciliation Services. It comes up as fmcs.gov. Go ahead and just look it up. I guess I'm not going to post that. That's too easy to look up. Look it up, people. Look it up. That's your job. Anyway, but I will post a couple more definitions in regards to arbitration coming from Bovier's and Duhame's. I will post those definitions as well, just to give you different sources in regards to what arbitration is. It's just basically your freedom of expression. You have to learn how to express yourself, though. You have to learn how to go to your brother in peace and love thy neighbor as thyself and say, hey, listen, brother, I'm sorry if I made a mistake. But the way I see it, I wasn't driving. I was traveling, and I need you to show me where I was driving. You know, as far as I know, driving is a commercial activity, and it's done with the intent of usage of at least 50% in the performance of trade or business, specifically for trade or business. I'm not employed by the government, brother. I don't perform the functions of public office. Could you bring proof proving that I was driving then in regards to that? Because otherwise there is no such record, and you're making a false accusation. And rather than coming forth and being belligerent, as I've done so many times, we need to learn how to change that. And that's, again, going right back to language is key. Not just in learning the right words, but being able to express the right words and being able to express them the right way. And that is in love. Again, my last video was an apology in regards to my own belligerence and the language that I use. So I'm going to make that apology again here. I'm working on it, people, but yeah, it definitely is a matter of going to your brother and making those amends, amending the contract by placing conditional acceptance upon it. I accept this contract. upon the condition that we here forthwith arbitrate various different terms and conditions that have already been acknowledged, while acknowledging future and further terms and conditions in regards to the bonds being run through the court registry investment system as domestic trades on the securities exchange market, and are regulated under applicable blue sky laws in accordance with the state uniform commercial codes. Blue sky laws are your securities laws within the states. Just like the uniform commercial code is your contract laws within the state, your blue sky laws are the securities laws within the state, whereas securities laws are dealing with your federal government, and that's where you get into the foreign exchange. Whereas your contracts with the federal government is where you get into foreign contracts. Your uniform commercial is your domestic contracts, and your blue sky laws are your domestic laws, and therefore they're done through the court registry investment system. And then once that contract and everything is finalized and they can renegotiate that bond, that's when they renegotiate it by selling it to the federal government. And now it's up for sale on the international market. When you learn this stuff and you comprehend how it all works, you can stand there in court and I guarantee you they're going to, I don't think we want this guy submitting that paperwork. I think we need to step into arbitration. They either need to gladly accept that arbitration, and that's when they see that fee schedule and they see how much this is racking up. When you learn this stuff and you can point out the different charges, the officer kidnapped me. It's well known through the Department of Justice that the traffic violations are unarrestable offenses, and therefore that should be known. They are to know this law, and they don't. I'm sorry, they enforced a contract. They kidnapped me. Kidnapping is a felony offense arrestable by 15-year penalty, along with the commercial charges. And when they realize this stuff, that's when they start realizing, wait a minute, I made a mistake. My brother's right. He's got me in here in a situation I'm not familiar with. Usually I don't have to show up in court because they just ramrod them through. Now all of a sudden I'm being pulled through in this kind of arbitration thing I've never heard of before. And he's talking about my bonds and his bonds and how we're going to make compensation for this and how I owe him thousands and thousands of dollars and I'm going to be subject to thousands and thousands of dollars in penalties as well as multiple years behind jail. And we're talking kidnapping and trafficking of persons and piracy on the road. Yeah. And if that judge actually knows what's good for him and that prosecutor knows what's good for him, they might want to think twice about it when they confront me, because I'm, like I said, I don't want to be belligerent, but I am going to stand my ground. And it's my standing that if you move forward in these kind of incidences, the prosecutor is acting in seditious behavior, in a seditious manner, and the judge is acting in a treasonous manner, pure and simple. And it's all construed through contract law. We see this through the implementation of the Clearfield Doctrine, where it's already been established. We go after them in their individual capacity because they've stepped down to that individual capacity as a private citizen. You now address them privately through arbitration and say, okay, let's talk about this, buddy. Let's get down to the terms and conditions of the contract you've already enforced. You've already had me subject to jail for 3 days until I appeared before you, because the officer wanted to kidnap me and falsely imprison me. And now you're here rendering some kind of judgment as if though I've made some kind of order of payment. I haven't made that yet. We need to come to terms and agreements of that order of payment first. See, according to this paper, it looks like somebody's trying to make some kind of promise to pay some kind of penalty. I don't see any promise anywhere. And that's why I say if I ever get another ticket or citation again, I'm gonna line through appearance and I'm gonna put arbitration, and I'll sign with my UCC 1-308, and then my old John Henry, and then I'm gonna take it to the prosecution within 3 days, and say and ask them if for verification if they're there to arbitrate, or if they're there to try to continue with prosecution, because I put an arbitration clause in there. And anyone that wants to additionally contract with that officer has to comprehend that there's an arbitration clause in there, and they are subject to it as well. I do not accept third-party interveners. Third-party interveners are subject to the arbitration clause. Period. So think about this stuff, people. This has gone on a lot longer than I thought it would, but I think it's all pertinent information, and I hope I expressed it in a way that you people can comprehend this stuff and dig into it enough to realize how important it is. A lot of us have been babbling. A lot of us have been belligerent, and we need to get down to the correction of all of it and come to peace with ourselves and learn the language so we can express it appropriately in the correct arbitration manner. Because again, if I go forward with the intent to love my brother, then I don't wish to go forth with a belligerence of any kind. And therefore I must at all times be willing to arbitrate, because I must be willing to comprehend that any time a controversy may arise, even if in error. Therefore I request forgiveness as I forgive those who have trespassed upon me. Let's talk about this peacefully, in His name, in His house, as stewards, both of like kind. Anyway, remember, folks, if it wasn't for you guys, I wouldn't be doing this. God bless. Love you. Have a great night. Bye.